Good morning, everyone. Welcome to this second EMFA Talk. For those who are not familiar with the EMFA Talk yet, these are debates that the Center for Media Pluralism and Media Freedom organizes regularly every other Monday at this time from 11 to 12:30 to discuss specific issues regarding the implementation of the European Media Freedom Act. I'm Urbano Reviglio, I'm a research associate at the CMPF, and I have the pleasure to chair today's event that I have organized with Elda Brogi, the director of the CMPF. So today we will delve into one of the most pivotal topics of the EMFA, which are the guarantees for the independence of public service media as outlined in Article 5. Indeed, in these turbulent times, it is fundamental to have independent media that are impartial, balanced, and ultimately trustworthy. So in this session, we are aiming to shed the light on some key issues. First, the current state of independent media, of public service media across Europe. Second, the practical changes that we can expect from the implementation of Article 5. And finally, what concrete mechanism can be established to safeguard transparency and objectivity in governance and funding processes of public service media. Today's event is structured to provide both expert insights and to foster an open dialogue with the audience. We will begin with a concise introduction to Article 5 from my colleague Matteo Trevisan, Research Associate at the CMPF. This will be followed by two presentations, one from Enrico Albanesi, Associate Professor of Constitutional Law at the University of Genoa, and the second one was planned Jenny Wynand, Legal Counsel of the European Broadcasting Union, which unfortunately she's sick, and she will be substituted by Alexander Foll, Senior Legal Counsel of the European Broadcasting Union. This presentation will be followed by comments from two other distinguished panelists, Cristina Rozzoni, Senior Scientist at the Austrian Institute of Technology, and Renate Schröder, Director of the European Federation of Journalists. After that, we will open to the Q&A. So we invite you all to engage in the conversation. And having said this, let us begin. I now hand over the floor to Matteo Trevisan for an introduction to Article 5 of the European Media Freedom Act. Matteo, the floor is yours.
Thank you very much, Urbano. So good morning, everyone. I'm Matteo Trevisan. I'm a research associate at the CMPF, where I supervise the political independence area of the Media Pluralism Monitor. I'm really glad today to have the opportunity to introduce and to moderate this panel with such a new group of experts, a panel which is focused on the essential article of the recently introduced European Media Freedom Act, Article 5, which provides relevant novelties in terms of protections and safeguards for the European public service media systems. So I think the best way to start this conversation is to introduce the provisions provided by Article 5 to proceed with a brief overview on the current state of things in Europe when it comes to the independence of public service media, thanks to the most relevant results of the last implementation of the Media Pluralism Monitor. As my colleague Urbano has already introduced, I will then leave the floor to our experts Enrico Albanesi and Alexander Foll with their presentation, which will be followed by a 10-minute round of comments from our other guests, Cristina Rozzoni and Renate Schröder, after which there will be another 20 minutes for Q&A from the audience. So, to begin with, we can say that in regard to public service media, the EMFA provides significant novelties, and for several reasons. The motivation behind it is the risk of state capture of public service media identified across Europe, which might be enabled by governance and funding procedures. So in terms of novelties, the first is the inclusion of public service media in the scope of an internal market enhancing regulation, something that is defined in paragraph 1 of Article 5. As a matter of fact, until the EMFA was proposed by the Commission, public service media were addressed by the EU law, mainly in relation to state aid rules linked to their financing, while specific provisions were for a long time regarded as being entirely out of the competence of the EU. So the EU is now recognizing the significance of public service media in maintaining media pluralism, and that have acknowledged such a rule through specific provision integrated in the first paragraph of Article 5. I'm specifically referring to Protocol 29 of the Amsterdam Treaties, which emphasizes the overall role of public service media in the society and the preservation of media pluralism, while recognizing the competence of the member states to define their national public service remit and their funding mechanisms. While very often the provisions of Protocol 29 have been considered an argument against foreseeing a general competence of the EU on the media sector, in the context of EMFA, it can be read instead as confirmation of the inclusion of public service media in the internal market, as it affirms that the treaties will not preclude the competence of member states to provide funding of public services as far as this is not affecting trading conditions and competition in the Union. Next, paragraph 1 of Article 5 now explicitly states that public service media shall be editorially and functionally independent and provide in an impartial manner a plurality of information and opinions to their audiences, and this in accordance with their public service remit, which, as already mentioned, clearly stems from the member states. And with the aim of ensuring such editorial and functional independence, EMFA then lists more specific safeguards in terms of governance and funding. In terms of governance, according to paragraph 2, the head of management or the members of the board will have to be appointed on the basis of transparent, open, effective, and non-discriminatory procedures with criteria to be laid down in advance. The duration of the term of office shall be sufficient for the effective independence, and dismissals before the term of office shall be duly justified, taken only exceptionally, and subject to the possibility of a judicial review. Similarly, on the side of the funding mechanisms, member states shall ensure that funding procedures are based on transparent and objective criteria laid down in advance, and that those funding procedures guarantee adequate, sustainable, and predictable financial resources, such that the editorial independence of public service media is safeguarded. And finally, paragraph 4 also provides that member states shall designate one or more independent authorities or bodies, or to put in place mechanisms free from political influence by governments to monitor the application of the above-mentioned paragraphs of the Article 5, with the results of such monitoring that shall be made available to the public. So we can see how Article 5 provides a relevant consideration of procedural aspects which will have to be now taken into account by member states, and that are likely to play a fundamental role in reshaping national legislations at the EU level against the risk of an infringement procedure. Indeed, if we consider the last NPM results, we observe not only that member states have a diverse range of procedures related to the governance and funding of national public service media, but also that the situation is far from being reassuring, as the NPM indicator independence of public service media presented a medium risk score of 53%. And more specifically, the sub-indicator public service media governance experienced a risk increase this year, indicating the grip that political parties keep accepting to management procedures, with almost half of the countries assessed presenting high risk results under this specific sub-indicator. But also the sub-indicator related to public service media funding presents only 8 countries are at a low risk level. So several open questions remain, especially on the side of the application of such procedures in practice at the national level. So without further ado, I will leave the floor to Professor Enrico Albanesi and his presentation. Thank you very much.
Okay, thank you very much, Matteo, and thank you all for this invitation. I'm very glad to be with you today. So my presentation will be on Article 5. I will try to make some comments on it, but after these, my thoughts will be on the domestic level. So I will try to see what the legal consequences could be on domestic legislation from Article 5 of the EMFA. And as you perfectly know, I need to underline a couple of points. First, the fact that the EMFA was published on the official Gazette of the European Union on April 2024, but most of its articles, including Article 5, shall apply from 8th August 2025. So the hypothesis that I would like to carry on today is the fact that domestic legislation that is not in compliance with Article 5 of the EMFA shall be modified as soon as possible. Why? Because from the 8th of August 2025, there will be some legal consequences on domestic legislation that is not in compliance with Article 5. So before making some comments on Article 5, I would like to make a preliminary remark. Matteo mentioned protocol number 29, under which public service remit is conferred, defined, and organized by each member state. If you read the explanatory memorandum of the proposal for the regulation that would become the EMFA, you can read that the initiative takes due account also of Article 4.2 of the Treaty on the European Union. This is important because, in other words, this means that the regulation will not interfere with national identities or regulatory traditions in the media field. Why I stress this point? Because from this perspective, I think it's interesting to note that national identity does not allow member states to jeopardize the common value of the European Union under Article 2 of the Treaty on the European Union. Why I'm stressing this? Because, as you perfectly know, public service media are essential to strengthen freedom of expression and information, which makes part of the core of the values under Article 2 of the Treaty on the European Union. And of course, I'm not stressing this just for a theoretical purpose, but because, as you perfectly know, some European Union member states have used so far the national identity clause just as a shield to legitimize their domestic legislation that was not in compliance with the common value under Article 2 of the Treaty on the European Union. So, as you perfectly understood, my idea is that these clause under the explanatory memorandum of the proposal cannot allow EU member states to jeopardize the values under Article 2 of the Treaty on the European Union. So let me now come to some comments on Article 5 of the EMFA. So what are the obligations of member states? Well, Matteo already read Article 5, so you already read the obligations, but I think it's important to stress some difference when it comes to the wording of Article 5 if compared to the original proposal. Because under the original proposal, the wording was something like public service media providers shall provide, etc., etc. The head of management and the members of the governing board shall be appointing, etc., etc. But the new wording is stronger, in my view, because you can read that member states shall ensure, member state shall ensure, etc., etc. So when it comes to the contents of these obligations, I would like to stress that these obligations at first glance look a bit generic because, as Matteo read, member states shall ensure that public service media providers are editorially and functionally independent, that member states shall ensure that the procedures for the appointment and the dismissal of the head of management aim to guarantee the independence of public media service, and that member states shall ensure that funding procedures for public service media providers are based on transparent and objective criteria. But what does it mean practically? Well, I think that we can interpret these three obligations relying on recital number 31 of the EMFA. Because under recital 31, we can read that public service media providers benefit for transparent and objective funding procedures which guarantee adequate and stable financial resources for the fulfillment of their public service remit. And it's very interesting. It's very interesting that under recital 31 there is a practical example, because you can read that such funding should be preferably decided and appropriated on a multi-year basis, in line with the public service remit of public service media providers. And the bad example is also given because under under recital 31, there is an example, a bad example, when it comes to some money, some grants given to these providers under the Yearly Budget Act. So that's a bad example, I would say. But there is another aid coming from recital number 31, because under recital number 31, we can read that these criteria under Article 5 of the EMFA can be also built on the international standards developed by the Council of Europe in that regard. So in particular, recital 31 mentions the 1996 and the 2012 recommendations of the Committee of Ministers of the Council of Europe. So why, once again, I'm stressing this? Because as I mentioned, recital 31 gives us some additional criteria to make Article 5 less generic at first sight it looks. So at the end of the day, when we read these obligations, I would say that we are talking about an article, Article 5. Sorry, can you please switch off your mic? Because I'm Matteo, can you please switch off your mic? Because I'm hearing everything. Thanks so much. Thanks so much. So, as I was saying, at the end of the day, when we read these obligations from Article 5 of the EMFA, I would say that we are speaking of a regulation. This is rather obvious. So, an act that is directly applicable, but we are reading an article of an act that looks like a directive. Why I'm saying that? Because Article 5 does not have a direct effect, so its provisions do not have an immediate application due to their wording, I would say. So what would happen from the 8th of August 2025? Well, from my perspective, from the 8th of August 2025, member states which such domestic legislation that is not in compliance with Article 5 could be subject to infringement proceedings initiated by the European Commission. Secondly, I would say that any domestic court could ask the European Court of Justice to issue a preliminary ruling in order to have Article 5 of the EMFA interpreted in the sense that it does not permit such domestic legislation that is not in compliance with Article 5 itself. Thirdly, just for the reasons I have just stressed, I would say that domestic courts, unfortunately, I would say, are not allowed to disapply domestic legislation that is not in compliance with Article 5 of the EMFA. Why? Just for the reasons I have just said. Although EMFA is a regulation, Article 5, due to its wording, does not contain provisions that can be immediately applied. Therefore, it is not possible to disapply any domestic provision that is not in compliance with it. Fourthly, I would say that luckily, in those countries, like for example Italy, where a case of constitutionality can be brought before constitutional courts when under the domestic system of constitutional review, such kind of antinomy between non-immediately applicable EU provisions and domestic legislation is the task of constitutional courts. Well, in those jurisdictions like Italy, I think that a case of constitutionality could be brought before domestic constitutional courts. And finally, another issue could be what could be the legal status of the head of management or of the members of the management board that were elected after the 8th of August 2025 on the basis of domestic legislation that is not in compliance with Article 5 of the EMFA. Well, once again, I think that this could be a case of an infringement to the EU law. So once again, I think that if a EU member state would appoint such a management board, well, this would be a case of infringement of the EU law, and in particular of Article 5 of the EMFA. So these are my ideas in a nutshell. I think, as far as I see, I don't have much time, but maybe after these I can bring you some practical example about the Italian case, that is the jurisdiction that I know best, of course, and that these, in my view, could be a good case study of domestic legislation that is not in compliance with Article 5 of the EMFA. So thank you for your attention.
Thank you very much, Professor Albanese, for raising these important points in such a pretty clear way. Actually, we have other 7-8 minutes for if you want to jump into the Italian case. Otherwise, we can jump later and proceed to the next presentation.
Okay, so in a nutshell, I would say that when it comes to the Italian legislation, the controversial article is Article 63 of what we call TUSMA. TUSMA is the code that is used in Italy for regulating all the system of audio visual media. So what is the problem of Article 63 of the TUSMA? Well, under Article 63, you can find the way the management board of the RAI, which is, as you know, the public service media broadcasting in Italy, Under Article 63, you can read the way the management board is appointed. Well, the main problem when it comes to these proceedings is that the criteria to select and to appoint and to elect the members of the management board are not clear, are not provided in advance as Article 5 of the EMFA requires. And another problem when it comes to the Italian legislation regards Article 5.2 of the EMFA. You remember that we were talking about Article 5.2 and we were reading the fact that the way the grants, the funds are to public service media should be decided in advance. And you remember that I made a bad example of funding. So the way that the Italian praxis, I would say, follows is just using the Yearly Budget Act. So as you can imagine, using the Yearly Budget Act to give funds to the public service media means that every year the independence of the public service media is jeopardized, because every year the independence of the public service media depends on what the executive, well, formally speaking, the parliament, formally speaking, the political majority of the day at the parliament decides. So in a nutshell, because I understand that it would be much more complex to explain all the Italian legislation when it comes to this issue, but in a nutshell, I think that these could be the two controversial issues when it comes to Italian legislation as a case study to let you understand my view of the picture of domestic legislation that is not in compliance with Article 5 of the EMFA.
So thank you very much again, Professor Albanese. I think that, of course, the Italian legislation and its gaps can be taken as an example of what could happen not only in Italy, but also in other European countries. When it specifically comes to the funding procedures, Italy is not the only case where the financing is given through this yearly budget. That's decided within the yearly budget procedure, so the government can have a say on this issue. We have 3 minutes for taking one question maximum, and then we can proceed to the next presentation. So if there's someone from the audience which would like to give a comment or has a question.
Can I?
Sure.
Giacomo Mazzone here. Thank you, Professor Albanese. I have several questions, but the one that for me is more important to understand. You said that the domestic court cannot raise the issue, so they have eventually to go through the constitutional court. The commission can. What about the other figures that can eventually? The single citizen can apply, or a union can apply to ask the respect of the EMFA in Italy, or only secondary steps made by the court through the constitutional court, which are the way that EMFA opens?
Okay, thank you for your question. I would say that okay, thanks. Again, please, the mic. Thanks again. So from my perspective, single citizens as such cannot do anything, simply because in Italy, once again, I'm speaking about the Italian case, there is no direct access to the constitutional court. But, for example, potential candidates to the management board, because as you perfectly know, in Italy, the proceedings that I was mentioning before to elect or to appoint some of the members of the management board, they can make a candidacy to be appointed and to be elected by the parliament. Well, sorry, to be elected by the parliament. So in that case, I would say that a single candidate as a citizen, as a private person, but who has a qualified interest, can sue before a judge, before a court, just because they can say that their rights under legislation that is not in compliance with EMFA were jeopardized. So I hope somehow I answered your question.
Okay, we have also a question from Luigi Malferrari, so feel free, and then you can proceed in 3 minutes.
Yes, thank you very much, Matteo, and thank you very much to Professor Albanese for the very rich and clear presentations. There's, however, one issue on which I'm not so sure, which is the direct effect. So direct effect basically means that an EU law provision is sufficiently provided and it is unconditional. When I read the provisions in Article 5, it seems to me that at least the vast majority of those provisions are both unconditional and sufficiently precise. If I also make a comparison, so you said that it's a directive, and therefore national judges cannot set aside conflicting national rules. But in fact, in the daily practice of EU law, we see recurrently examples of EU directives that preclude the application of conflicting national rules. I would just give 2 examples that somehow resonate with the content of Article 5. One is Article 15 of the Services Directive, whereby member states shall ensure that certain requirements are non-discriminatory, justified, and proportionate, and also the the articles in the Electronic Communications Code, previously the Framework and the Authorization Directives, which provide that the assignment of TV frequencies need to be done in a transparent, proportionate, and non-discriminatory procedure, and according to proportionate, non-discriminatory, and objective criteria. So in the case law, it is clear that those directive provisions are directly applicable. And that means that individuals can bring proceedings before national courts and can invoke them against conflicting national legislation, which then must be set aside by national rules. So I just wanted to have a little bit more clarity on this, because to me, Article 5 is at least the vast majority of those provisions is a clear case of directly applicable provisions. But and this is also to follow up on what Professor Mazzone said. Thank you.
I will ask kindly Professor Albanese to answer possibly very briefly, and as we need to proceed with the second presentation. Thank you.
Okay, very, very briefly, because maybe we have 2 different views. So I hope to be wrong. So I hope that the other view would prevail, because of course I'm rather worried about the domestic legislation that is not in compliance with Article 5. But in my view, it's not so easy to apply these provisions, because once again it would give maybe too much discretion to domestic courts. So this is why I think they need to be implemented in a more, let's say, concrete, in a more practical view. So maybe we have simply two different views, but once again, I hope to be wrong.
Okay, thank you very much, Professor Albanese. I think we can move up to the next presentation from Alexander Foll, European Broadcasting Union. The floor is yours.
Hello, hi everyone. Alexander Foll from the European Broadcasting Union. So I'm stepping in today for Jenny Weinheim, who unfortunately sick and couldn't make it. So I'm a senior legal counsel for the European Broadcasting Union. I've been working with Jenny on the implementation of the PSM safeguards and what they could mean from PSM. Just a broad disclaimer, the views that we're going to share today are reflections from the permanent service of the European Broadcasting Union and does not constitute final views of the EB on the matter. So I just wanted to pick up on what Professor Albanese mentioned previously, which is the major shift that the European Media Freedom Act will constitute for public service media and what it can mean for PSM independence. So we're talking about their survival, but also what they mean European-wide for free press and trusted media. So I'll just remind briefly what the EMFA says in our view. So you have another overarching principle within this Article 5, which is basically that PSM should be editorially and functionally independent. And this principle transpires throughout all the subsequent provisions. So it's in light of this principle that, in our view, all the subsection of this article, so Article 5.1, 5.2, and 5.3, should be interpreted. So I'll make a focus here, especially on the funding and governance aspects, due to the limited time that we have today. And then hopefully we'll have a bit of time for questions. So the Article 5 enshrines a broad principle for editorial functional independence, but also a balanced coverage requirement, which is basically that PSM should provide impartial reporting, governance obligations in relation to PSM managers or management boards, for requirements regarding to the appointments in particular, funding procedures to ensure that the funding is adequate, sustainable, and predictable. And finally, it refers also to PSM oversight. So the need to have independent national regulators monitoring such provisions. So what it means in practice. So the balanced coverage requirement and the obligation to have editorially and functionally independent PSM is already enshrined in EU law, albeit in particular in Article 10 of the European Convention of Human Rights, but also in many PSM laws. Many PSM laws already provide for such balanced coverage requirements, and have been for many years. And what's interesting is that Article 5.1 not only refers to the balanced coverage requirement, but also to the scope of PSM remits. It basically says that everything that Article 5 commands needs to be done within the confines of PSM remit, because the EMFA is mindful of the delineation of competence between member states and the EU, the European Union. So interestingly, when we look specifically at the scope of the remit, there is sort of a dialectic between Article 5.1 and Article 5.3, which mentions the capacity of PSM to develop within their remit. And this is something that, in our view, is very much important, and that commands a broad remit for PSM to be able to appeal to all facets of the society, to provide all genre, including entertainment, and to be able to reach citizens where they are. So that also means to be present on all platforms. That being said, we already see many challenges to the implementation of this provision, in the sense that we see across many jurisdictions the remit of public service media being reduced. That is a recent example in Germany, where the ability to provide news online was further reduced. And so this narrowing down of the remit is something we see more and more. For instance, in Netherlands, they are calling for the removal of entertainment programs from the remit. And we see also the far right in Austria asking for ORF's remit to be stripped down. I'll now turn specifically to the governance provisions. So the governance provisions are mainly geared towards PSM management, so directors and management boards. So when we look at the provision itself, it is drafted in broad terms and addressed to member states, as Professor Albanese just mentioned. And so what it covers is PSM, the appointment procedures and the dismissal procedures. I basically said that the procedure needs to be transparent, effective, and non-discriminatory. But what could that mean in practice? So practically, there are various ways to interpret it, but we based our views mainly on the Council of Europe recommendations, which form the basis of this specific provision of the EMFA. And when you look at those Council of Europe principles, there are already some very interesting recommendations in there, which would be, for instance, to restrict the ground for dismissal of PSM manager in order to avoid decisions that are linked to only politically motivated, specify the terms of the manager, which should not exceed, for instance, 4 to 5 years, which is a rule that we see already applied in many countries where governance works well, and also a strengthening of the incompatibility rules and conflict of interest rules to ensure that PSM manager acts independently of third parties. So those are just a few examples, but when you lay out the examples, you also face challenges at national level, like we've seen recently. I'm missing a slide here. Okay, there it is. So we've seen recently in Slovakia that the government has tried not only to change the funding model, but also to enact a whole reform which would reduce the independence of the broadcaster, in the sense that the governance safeguards, certain governance safeguards had been lifted. And which is why we think that it would be interesting to have some soft guidance on the implementation of such provisions. Just bouncing back to supervision, the Article 5.4 refers to the need to have mechanisms in place at national level to monitor the Article 5 provisions, and we think that the agency that is designating, for instance, the National Regulatory Agency, the members of such agency should be protected against unjustified dismissals. We also think that there should be a strengthening of the independence of the supervisory board and a protection against politically motivated dismissals. So those are just rough ideas that we've laid out there. In relation to funding, the funding provision, which is basically the Article 5.3 provisions, which mandates procedures, transparent and objective criteria to ensure the adequate, sustainable, and predictable funding of public service media. We think that there are various interesting examples within the EU that could be relied upon. So first, to ensure the independence of public service media, funding allocation should not be impacted by political cycles. So typically, you should avoid to have a yearly allocation, which means that whenever you have a political change, they can strip down or reduce the level of funding. Then, in terms of predictability, it is interesting when you have a mechanism whereby the level of funding is not determined necessarily by the political authorities, but rather by an economic model, which makes sense. For instance, macroeconomic indicators, a percentage of GDP, something that works in certain countries. And you would need also to cater for the inflation, which is something certain jurisdictions neglect to do. Then the adequacy of funding is something very, very important. And you have in certain jurisdictions, for Germany, for instance, mechanisms whereby you have a specific body designated to ensure that the level of funding is sufficient to fulfill the remit. And this step only intervenes after the remit has been defined properly. So it's a separate process in a way that works very well, and that could be an example that could be relied upon. And then when it comes to sustainability, it's interesting to note that the less you are exposed to commercial revenues, the less volatile the level of revenues are. I mean, when you have 30% of your income based on commercial revenues, like in certain jurisdictions, it's much more challenging to have sustainable funding. So those are just a few examples we've put out there, but those principles would be hard to implement, judging by what we observed in many jurisdictions. Why so? Because we observed over the past couple of years a range of budget cuts in various jurisdictions. So those are either drastic cuts that are very sudden, like in Finland, in Belgium, or in Netherlands, or they are linked to a shift to another funding model. For instance, shift to state budget models led to funding cuts in Denmark, Romania, or France, and didn't cater for inflation, for instance. But when it comes to drastic cuts, we're talking about 10%, 20%, or 40% cuts straight up that intervened, for instance, recently in Finland, mainly due to a change of government. And so we contend that those drastic cuts necessarily induce a reduction of PSM remits and threatened their ability to reach out to citizens and fulfill to their remit, basically, because it's much more difficult for them to innovate, to be present on all platforms, to appeal to the different fringe of the population. So this is the challenge we also observe on the funding side, besides the traditional fact that inflation is not catered for in budget negotiations. So I hope I gave you a good overview of where we think that implementation could be an opportunity and the risk we face in the implementation of such provisions, which is why we think that it is important to raise awareness at national level, to be extremely vocal, and ahead of the entry into force of the European Media Freedom Act. Thank you very much, and I'm happy to take any questions if there are any. Thank you very much.
Thank you very much, Alexander, for a great presentation. I think we have 5 minutes for taking maximum 2 questions, and then we can proceed with the scheduled round of comments from our other guests, Renate Schrader and Cristina Ruzzoni. Okay, then if no question, we can proceed with Renate Schrader, Director of the European Federation of Journalists. Renate, the floor is yours.
Thank you very much. First of all, once again, for this really excellent overview on an article that is specifically important to the European Federation of Journalists, because we are dealing here with the independence of public service media, with its financing. I think all the speakers, specifically just now, our colleague from the EBU showed us how much public service media is under pressure. We have seen it also at the beginning, thanks to the MPM monitoring, how many countries are at high risk, and I'm afraid it will get worse. I've seen it also now from my own country, Germany, where, as we have seen, there are increased attacks regarding the public service minute. You all know we are in elections, and PSM is under enormous pressure. And yes, we have this article now, and I thought is specifically interesting to hear slightly different views about the preciseness of this article. I sort of agree with Professor Albanese, who says it sounds a little bit more like a directive. It is, in our view, rather principle-based, which, as so many other articles in the EMFA, make it, of course, much more difficult and complicated to apply. Having said that, I think it shows how important it is to have such meetings as today, because I can only say from our affiliates, who many of those are here today, from the north to the south, it is very complicated indeed. And without media experts, without experts on this one, specifically on public service media, our national affiliates and unions will have difficulties to enforce it, to go to the courts, as it was also that one of the questions was, who can go to the courts, and can go unions to the court? We had already partial responses. We in Brussels will now do a lot to put pressure on the European Commission to take the enforcement extremely seriously. It will all take time. And then at national level, we have to follow our members to probably, in many countries, I'm afraid, go to the court. The Italian example is, I think, extremely interesting, to say the least. We have been following very closely. We also had a mission to Italy. And of course, the attacks on the RAI have been the center of our concerns regarding press freedom in Italy. So it will be, and we know about the developments going to the constitutional courts. So we will follow that very closely, and we will hope to get something positive out of it, because what we will need now in the future is really case law, as we had it so often when we are talking about Council of Europe standards. Last week, or 2 weeks ago, we had on Article 4, and we have 21 court cases that are explaining the importance of protection of sources, and yet it's being violated by member states day by day. So now we have, and it was said as well, for the first time ever, we have a internal market specified regulation of public service media. My colleagues from the EBU, even within their member states, know that it was not difficult. But I see more and more, we see the relevance for it, when even the public remit is under danger, when there's not enough financing to allow public service remit, which is ever more important in our fragile information system, we really have problems at large. So I will not summarize what has been said. I can only say for us, it's very important also to get the input in written form, and difficult times lie ahead of us, and we have to work together, and we need this network of media experts. So thank you again very much for all of you having taken the time. I would like our president, Maja Sever, who works for the public service media in Croatia, also to say a few words, because the EFJ is doing a campaign on public service media, and the EMFA within that has a very important role. So for now, thank you very much, and maybe a few words, Maja. Thank you.
Thank you very much, Renate. Maja, the floor is yours.
Thank you very much. I hope that you can hear me. I am now on public media service in my newsroom, so I really have to be short because I'm in the open space newsroom, surrounded with a lot of colleagues who are working, but very interesting and very important webinar for us. I see on a list of participants also colleagues from our association, because we have a plan on a national level for forming a group of the people, media experts, people connected to public media service also, to work on a national level on implementing of EMFA. It's so important of us, and from my point of view, from Croatia, from public media service, but I see also on a list a lot of colleagues who are working on these issues in their countries, and we really need expert inputs. I can even say the guidelines, what to do next. In Croatia, particularly, we have to demand and even propose very fast opening process for changing legislation about public media service, because it's opponent to what the European Media Freedom Act proposed. For example, our general manager has to be elected in a parliament by political majority, which is not following Article 4 of European Media Freedom Act. So we are really exciting that we will we have this document, and now as Renate said, we need concrete plan, we need concrete steps and guidelines what to do next. During this webinar, I already corresponded with my colleague in association. We have some more questions, but it's not now for this part of debate. But please, let's work together on it. We need your help, and it's really, let's say, hope and a chance for us who are working, but not just for us who are working in public media service, but for all of us in European Federation of Journalists who are aware of importance and important role in every media environment for public media service. And I think that together we really have to, and we can work on defending idea and surrendering of public media services. So that's from me for now, and maybe we will continue with questions, and I hope that we will continue in a further cooperation in our concrete steps on a national level, not just in Croatia, but with our affiliates, with whom we really work a lot in our expert group and in daily contact to try to provide them concrete advices and help in implementing European Media Freedom Act. Thank you.
Thank you, Maja. And if I can just, and then before finishing, again, even the EBU said we need soft guidance. We just had a meeting actually with the European Commission on guidelines for Article 18, and we felt it was up to us to give the guidelines. I mean, it's good to be consulted, but it's very difficult. So a pledge, how can we or who can help us in having such guidelines, even though knowing that each member state is different and maybe it's important to have national guidelines, general European guidelines wouldn't even help us. This is just my sort of invitation and question to the debate.
So thank you very much, Renate and Maria, for your comments. I think we can proceed with Cristina Rosgoni. So Cristina, the floor is yours.
Thank you very much. And thank you very much for organizing this event, because I think this is going to be one of the most important questions around the EMFA, whether we have these type of discussions when we can go beyond the letter of the law, as you would say, and look into the nitty-gritty details of how it works and what did this bring to the European media policy field. So let me briefly respond on two issues. First of all, thank you very much for Professor Albanese for this very detailed and throughout outline about the legal framework of the EMFA, and I couldn't agree more. You've mentioned that the EMFA on several occasions rather reads as a directive than as an act within European Union law. Again, I couldn't agree more. Several experts all across the European Union in the time of drafting the EMFA were giving the triggers and trigger warnings, so to say, that without meaningful enforcement mechanism built into the EMFA and built around the EMFA will be rather, I quote here, an empty compilation, a compilation of empty wishes. And I think this is one of the things that we really need to be aware. What do I mean by that? As we clearly remember, the triggers to the EMFA were very much the so-called bad apples within the European Union member states who had severe, long-standing issues about media freedom. Several countries, for example, across Central and Eastern Europe. I could name also my home country, Hungary, being one of them. What kind of changes could bring the EMFA as a response to the wicked problems of these bad apple countries? I would say it seems right now to many information that not much. Why am I saying that? There is a wonderful series of reports, and I put it right now into the chat, produced by the International Press Institute or on behalf of the Press Institute, looking into media capture across Europe, and who are using a very really complex and great methodology to look into the issues about media capture. One of the issues that they are looking at is independence of public service media. So what you can see, if you look into the first set of reports they have already published about Romania, Poland, Hungary, Slovakia, Bulgaria, and also Greece, is one simple statement that despite the legal framework, what does that mean? It means that the jure situation in these countries very often already complying with the EMFA is absolutely in contrast with the de facto situation. So, if you again, I don't have the time to go into the details of what is put into these reports. Just look into the dedicated chapters. What you will see is that in many countries, the text of the law is already brought into formal, and here's the emphasis, alignment with the EMFA, while the practice is not. So what is going to happen in those cases? What EMFA says, Article 5, for that the independent authorities or bodies should monitor the application, right? So the national regulatory authorities, this is who we are talking about. But many often, the national regulatory authorities are as much captured as the so-called public service media organizations. Or in some cases, like Poland, even more. So what is going to happen if the similarly politically captured media regulator has the job to monitor independence of public service media? Who is going to control the controllers? And this is something that has been raised in the context, for example, of Hungary. And now my question would be, let's just, make this kind of exercise. Let's think about what is going to happen. Is it the board of the regulators who will say, hey, you regulator from that particular country, you did not do your job? And who else is going to do the job? Is it civil society organizations? Is it NGOs? Do they have the capacity for that? Who is going to take this into account? Is the board going to set up a separate working group for the bad apple regulators who were not doing the job? I mean, I think I'm trying to giving you some examples of how tricky it is going to be to go after whether EMFA was actually implemented. So this is one remark. The other remark is regarding the issues that EBU has brought about funding. I absolutely agree with you that limiting funding to PSM is one of the major issues we are witnessing all across the European Union and all across Europe. But here again, one of the tricky questions: what if the problem is not underfunding but overfunding? What if the problem is because of corrupt practices, is providing funds in a corrupt scheme to public service media? So how and who is going to highlight, who is going to give a spotlight on these issues about corruption, which is a very, very, let's put it this way, liked practice at many bad apple public service broadcasters. So putting or summarizing my remarks here, across Europe, we are going to witness more and more systemic attacks on PSM and on the independence of public service broadcasters. You mentioned already Germany and the threats of limiting the development and meeting and fulfilling the remit. I can also mention Austria, the country I am based in. We see that one of the biggest issues about the newly forming government talks is how to further limit ORF's room of maneuver with using funding cuts or other governance interventions. So these kind of questions about the enforcement, I think, are going to be or should be on the top of our agenda while looking into the future and the meaningfulness of the EMFA. Thank you very much.
Thank you very much, Christina, for raising these important points. I will now open the Q&A session that will last for 20 minutes. I already seen some hand raised, so I will start from Professor Tirmisi-Parcu and then proceed with Alexander Fall and Elda Brogi.
Yes, thank you. It's a very interesting debate. It confirms that was a good choice to move through the articles of the EMFA. I have a consideration based on the NPM. Matteo showed at the beginning the NPM result, recent NPM results about the situation of the public media service. And I think that this is a result that is particularly well polarized. So we have a lot of greens and a lot of reds. That shows that there are many countries in potential troubles and several countries that have a solution that is acceptable. And I think that this is very a good news, because the fact that there are different acceptable solutions from different countries with different tradition and history is positive, because probably, as we are doing with all the EMFA articles respect to the NPM indicators, we could try to check if these greens are fully compatible, and then maybe produce a list of acceptable solutions that could be interesting to propose to the discussion. And this clearly will not solve all the problems of what will happen, but may help the countries that will pursue a fair alignment in this to Article 5, that want really to reach the result, and helps, on the other hand, to it will not help the governments that don't want to align and instead attacking on compromising the independence of the public media service, but maybe could help to cut this divide, and then we will have a better route for understanding which solution and which countries need to be will need legal solution and legal responses. So I think that this is an area where the NPM history really can help. Thank you.
Thank you, Luigi. I don't know if someone has some reaction to Luigi's comment, otherwise I will proceed with Alexander. Okay, Alexander, you can proceed.
Thank you. Just a brief comment on Renato's and Cristiano's intervention. I just wanted to say that we fully concur on the fact that we do need to rely on guidance a way or another in relation to Article 5 specifically. However, due to the different national contexts we observe, we know perfectly that some countries are working very well, some systems are better than others, some systems basically cannot be implemented in other countries for cultural reasons. So I think that it'd be great to rely on best practices rather than recommendation, because recommendations are very hard to craft in relation to Article 5 due to the diversity of national context. In relation to the points mentioned on NRAs and the fact that they can be sometimes politicized, I think it might be something. They might be politicized in such an instances, but a way forward, as we've mentioned, is to ensure that you have rules related to the other side, specifically to ensure the independence of the members of the NRA. So those could be best practices, for instance, to put forward. And in relation to the point mentioned by Christina of PSM overfunding, I've unfortunately never heard such thing as PSM overfunding, especially because you have a mechanism under stated rules that basically say that any funds in exceed of 5 to 10% that you receive need to be to be refunded. So in stated investigations, we've never evidenced overfunding issue. I mean, the commission never did so. But underfunding is something we're looking at closely together with the MFF. Thank you.
Thank you very much, Alexander. Elda?
Thank you, everyone. I use this opportunity to thank Professor Albanese and Alexander Fo from the EBU for the interventions. I think it's a very interesting debate, as well as Renate and Cristina for their participation, and Maya, of course. And listening to you on the one hand, I think that in any case, the European Media Freedom Act, even if it's a little bit broader than expected and a little bit less detailed that we aimed to at the very beginning, in any case, gives a lot of additional safeguards and potential ways of acting, submitting appeals against a situation that in any member states could be seen as not compliant with the principles that are somehow that are common principle and should be followed at a European level, since there are already standards in this case, in this regard. Because if I think of a EMFA article that could be grounded on principles that already exist, and also in some rules that can be tangible, really practically implemented, is exactly Article 5. There are the standards of the Council of Europe. There are, and in this regard, I thank Pierluigi that mentioned the Media Pluralism Monitor, that are somehow already written in documents, official documents, and in the academic work. If I think, for instance, of the issue of the funding of PSM, there are many articles, many standards, and already good practices that could be used. And that said that, for instance, at least as I said in the chat, the standard in order to be low risk is when a multi-annual funding system is in place. So I subscribe somehow the call of Renate that we really need to put in the same document some standards that can be really used to interpret this Article 5 and grounded on the literature that already exists, and compile a strong document that could be used in order to interpret this Article 5. And because, again, the European Media Freedom Act is also an act, a piece of legislation that relies, on the one hand, on Article 3 of the act itself, that on top of everything says that there is a right of recipients of media services. And maybe, and this is a question, this could be triggered in order to address situations that are not in compliance with the standards of the act itself. And on the other hand, we have to keep in mind that somehow the structure, the idea behind the European Media Freedom Act is also trying to create a mechanism through which there is a European discussion about what's going on at national level. There is the board, there is the commission, so probably there is also another level in which some problematic cases could be discussed. Thank you.
Thank you very much, Elda. We have a comment or a question also from Sasha Dobrevich. Sasha, the floor is yours.
Thank you very much. I'm the only diplomatic international journalist from Serbia, and I have a very short question. If we imagine that all these problems are overcome, what is the long-term vision and what will be the future problems? Is this some kind of utopia, or what about competition? What about all other things? Let's say that everything is perfect now and that there is no problems that we are talking about now. That would be my question. Anyone?
Thank you very much, Sasha. I don't know if someone from our guests wants to address these questions.
I think it's too utopian for me.
Okay, I've seen that also Roberta Carlini from the CNTF has a question. So Roberta.
Thank you, Matteo. I have the two questions actually. One is about the role of the independent authorities in these alternatives. If the Article 5 is directly applicable, and if the courts can decide, or as Professor Albanese was suggesting, there is the need of a pronunciation of the constitutional courts on the compliance of the national legislation with the European Media Freedom Act. There is this role of the independent authorities that, in case in which they are really independent, and this opens another issue, but in this case, if the national authority, let's say, as an example, in Italy, says, okay, now the European Media Freedom Act is law, it is in force, and it is our responsibility to say if, to assess if the Italian law complies or not with this criteria. Maybe this can be also a way to accelerate the implementation of Article 5. And the other question is who can go to the courts in case. I think that I would ask to the lawyers among our experts if it is a case in which everybody can have a legitimate interest to go to the courts. So the journalists of the public service media, as well as the citizens, because they have the right to good and correct information. I have also a third issue a third topic that is on advertising, because it is interesting, this debate on overfunding and also on the role of advertising. For example, reducing the advertising for the public service media in times of media economic crisis can be a very good move toward the commercial and the independent private media, because they can have more resources, whereas the public service media can count on public money. At the same time, for example, introducing limits or eliminating the advertising for public service media can reduce the independence of public service media because of adequacy of funding. So this is another dilemma that I would pose in the interpretation of the funding part of Article 5. Thank you.
Thank you very much, Roberto. So I will remit to the lawyers in our audience to address at least some of the questions posed by Roberta briefly, and then I will leave the floor to Giacomo Mazzone, who has another question, to then coming back to our chair, Urbano Leviglio, to close today's discussion. Yes, Alexander?
Just to say that when it comes to invoking the legislation at national level in relation to the independence of NRA, this is also a national law issue, because the recourse at national level will be different from a country to another. In certain jurisdiction, you'll go to constitutional courts, in others not, and certain jurisdictions have already developed case law in this respect. For instance, in Austria, some others did not. So citizens will not be in equal positions in their different positions with respect to how those rights will be invoked at national level, regarding specifically enforcing Article 5.4, meaning the oversight of the national regulator or the mechanisms put in place. So you would need to run such analysis in 27 jurisdictions.
Thank you very much, Alexander. Giacomo?
Yes, I have different points that for me need clarification. For instance, one question for Alexander is about the fact that EBU issued a paper in which he says that with the EMFA, this will be the end of retention by the private sector for the slicing exercise of the public funding. I have discussed this with other people, and they said that the interpretation of you is not confirmed by the reading of the EMFA. This would be important because, as you know, in Italy, in 2 years' time, there will be the renewal of the contract between the state and the RAI for the public service, and there are already many editorial groups that are asking to access the public funding. So I would like to know by certitude if this way is precluded by the EMFA. The second is the capacity of initiative from the EC. We have not discussed about that. We just mentioned at the beginning. So if I understand correctly, it's not possible to go directly to the court, in Italy at least. We have to go through the court that then eventually go to the Constitutional Court. And the case of the people that have a vested interest, like the candidate for the Council of RAI, could be a way, and is already on his own way. So we will see what will happen. But what about the European Commission? They announced that they will start to monitor and to make assessment now, not waiting for the August deadline. So this means that we can push on the European authorities to start immediately in all the countries, especially in the red countries of the EIU map, and ask to this government before the deadline to comply with that. And I know that the Parliament is also promising to monitor this initiative. So what we can do with the Commission in order to push them to intervene, I mean, civil society, unions, etc., and what will be the role of SEM, because explicitly the EMFA says that SEM can intervene in countries if they see that there is something in the national regulation that is not complying with the EMFA rules. So I would like to have more clearance on which are the spaces of intervention. Thank you.
Thank you, Giacomo. I think there was a question for Alexander, at least the first.
Can you hear me?
Yes.
Okay, good. So I'll just try to address this couple of points. So first, on the question of whether private operators can request public funding. So public service media provider in the meaning of Article 5 are defined in Article 2, paragraph 3 of the EMFA as media service providers, which is entrusted with a public service remit under national law and receives national public funding for the fulfillment of that remit. So you need to be entrusted with a remit, but also to receive funding for such remit, even if it's a slice of it, like in certain jurisdictions, like in Luxembourg. So I don't know what you mean by private operators, but that is the definition of the EMFA. So you are covered to the extent that you received funding to fulfill a given remit. So to us, we're fine with this definition and we'll work with that. But to us, it doesn't cover technically private operators. Second, your question regarding the monitoring of the provisions of Article 5 and how the Commission will enforce Article 5, well, it's not really for us to tell. What we understand is that given, as we've said, the delineation of competence between member states and the European Commission, the Commission is obviously limited in the extent to which it can enforce this Article 5. And so at the moment, we understand that it's meant to rely mainly on peer pressure and to have preliminary round of discussion before to go to taking a country to court. So we just hope that we will have an enforcement at national level and political moves to ensure that the new range of rules to comply with the EMFA will be workable. And we observed already from now on a range of consultations, for instance, in Poland, but also in other jurisdictions, specifically on EMFA, to try to comply as much as possible with the new regulation. So we will wait and see for the moment.
Thank you, Alexander. I see. I will take a last question from Luigi Malferrari, and then we will proceed with closing the event. Luigi.
Thank you. Thank you, Matteo. No, I just wanted to clarify two things. First of all, the fact that Article 5 in many regards resembles, in terms of drafting, a directive does not at all exclude the direct applicability. And the fact that there are a lot of provisions in Article 5 that leaves a lot of discretion to authorities does not exclude the direct applicability either. This was clarified in the 90s by the Court of Justice, for example, in a case called Kreiveld, where the court held that unimplemented provisions of a directive may restrict the discretion that is left to national authorities. So that was my first clarification. The second clarification I wanted to make is that so the Commission is been monitoring the compliance with Article 5 already now, and in fact, it is not limited to peer pressure. There is a legal benchmark because under the case law, member states, even before the entry into application of provisions, are under a duty not to frustrate the applicability, the legal normativity of provisions. So in this case, no member state can take measures, for example, Slovakia can take measures that frustrate the effectiveness of Article 5 even before its entry into application. Thank you.
Thank you very much, Luigi. So I think that today it was a very fruitful discussion. I want to thank once again our guests for providing the relevant insights on several issues related to today's topic. We have seen what could happen when domestic legislation is not compliant. We have seen what some solution could be at the practical level, as Alexander had provided some examples, especially in relation to the funding in his presentation. We have also seen that there are risks of having the legislation already compliant, but with problems in terms of implementation. So what emerges clearly is the need of further discussion on this issue. And thank you again for your participation. I will leave the floor now to the chair, Urbano. Thank you.
Thank you very much.
Thank you, everybody.
Bye.
Bye-bye.
Bye.